Thank you. So we could clearly cover 43 different subjects, so I'm going to cover a couple, and then I'll do Q&A where y'all can ask me any of the other 25. At that point, so first of all, happy 55th birthday. Lewis must have gone up to me a month or two ago about a date to come here, and we got a date that worked, and then I think Tuesday or Wednesday I got this frantic email, "You are coming this Saturday, right?" And I said, "Yeah, it is on my calendar." So it's my pleasure to be here. It's sort of neat to be here because candidly you're about 30 minutes away from me, which I can't say for a lot of the balance of the state. So coming to Cartersville is easy. And I've got a lot of good friends here, and so it's a pleasure to be here. You've got a beautiful downtown. You actually saved a lot of your old buildings instead of tearing them down, which is a real good thing. As an aside, Representative Kelly, I served with Billy Croker. You have your hands full. From Polk County. I served with him on the Department of Community Affairs and ACCG with my 12 years of local government in Cobb County. So he's a character. So what are we going to talk about? I'm going to talk about 3 things that I've worked with the legislature to pass, and then we're going to talk about federal overreach. So this past year, the bill, we only had one bill that we proposed. We helped the legislators and we helped the governor, etc., on numerous bills and helped with the wordsmithing, the drafting, etc. But we normally have 1 or 2 bills that are our bills that we get folks to sponsor and to assist with. So the one this year that we dealt with was pill mills. And this area, frankly, is very familiar with pill mills because you had one of the biggest in the state going for a good amount of time. So what I tell folks about pill mills, so if you drive by a strip center and you see one of those tacky signs that are looking at you as you're passing the strip center and it says, "Pain Clinic Walk-ins Welcome," y'all ever see them? Okay, so let me see if I got this right. I got a chest cold. I want to call my doctor to get penicillin or Ceftin, but thanks to managed care, I can get an appointment in 2 days to get that penicillin or Ceftin, but I could walk into a strip center and get OxyContin in 10 minutes. Yeah. You don't need a history, you don't need a physical, you don't really need a prescription because many of these places just gave it out in cash. So about 2 years ago, the state of Florida passed a bill, and at that time, over 95 of the top 100 prescribing doctors in this country for OxyContin were in Florida. And they were coming up the interstate system. So for instance, you had the governor of Kentucky going to the Florida legislature saying, "You need to pass a bill because folks in Kentucky are dying due to y'all." So Florida took care of it, and folks moved up north to Georgia. And I think it was December 27th of this past year, there was an article in the Wall Street Journal where a used car lot dealer was quoted as saying, "Well, heck, when Florida took care of it, I just moved to South Georgia." Now, what a used car lot dealer should be selling OxyContin for is beyond me, but he was. So thankfully, we went to the legislature. They passed the bill this year, so effective July 1, the medical board has the authority to license and regulate pain clinics. So if you're a professional doctor and you treat people with intractable pain, you do histories, physicals, and you do give people strong pain medicine that they need, but it's for them not to be a drug dealer. And the purpose of the bill was not to stop doctors from treating patients with real problems, it was to stop drug dealing. So I was real happy to get that bill passed this session. The prior year, the big bill we passed was a total rewrite of the Sunshine Laws, open records, open meetings. Make it more accessible for the public to know what their government was doing and make it cheaper to get records from their government to update that. And then the year before, our big bill was sex trafficking. So putting that in English, sex trafficking is the sale of children. So I'm not talking about a 16-year-old with makeup. I'm talking about girls as young as 12 and 14. And according to the FBI, Metro Atlanta is one of the top 14 areas in the country. We pretty much have an indictment or an arrest weekly in the state regarding sex trafficking. In fact, when the bill passed the House and we were working on it in the Senate, there was an interesting fact pattern that arose in Dodge County, which was really important to me because, the folks in rural Georgia think that this is an Atlanta issue, and it's a state issue. There is no urban rural, it's everywhere. We had a case in Dodge County in Eastman where a family had a 1998 minivan, $298 a month payment. They decided it was a brighter move to sell their 13-year-old to the used car lot dealer in return for not making the minivan payment. Mom got 8 years, Dad got 10, used car lot dealer got 10. Totally unacceptable. In the new law, it's 25 to 50 your life when you, without volition, without consent, sell a child for sex. So this past year, there was a deputy sheriff who stopped a car, either on 16 or 20, I forget which. It was a Tolliver County deputy. And guy in the front seat, girl in the back, and it didn't smell right to him. And the reason it didn't smell right to him was House Bill 200 required mandatory training for law enforcement, and this deputy had recently gone through that training. So he called the GBI for backup because the GBI are the experts in this area. They have a unit, ICAC, which is a national program, Internet Crimes Against Children, and they take the lead for us and do a really, really good job. And the long and short of it is they called the GBI agent in the area's backup. Ended up the girl was 17. This was her 5th state to be trafficked starting at the age of 12. So I'm a big fan of the starfish theory. You can't save everyone, but everyone that you do save is really, really good. And as you might imagine, when you try and save a girl like that, that's not a weekend program. You know, you're talking months and months of counseling and assistance to bring back that child's life to any type of normalcy. So it is a huge endeavor. The Governor's Office on Women and Children is very active in this area. There's a sort of an umbrella group that works with a lot of churches that is Street Grace. I would suggest to you, if you're not familiar with the Bartow churches working with Street Grace, I'd really encourage it. I can give you the lady's name who heads it, because it is clearly a big problem. We had a case actually in DeKalb County recently where they convicted a guy, sent him away for 40 years. He was so up front, he did a video in downtown Decatur telling other pimps he would tell them how to do it. So we were happy to get him sent away for 40 years. So big, big problem in our state. So we spend a lot of time in the office on child safety. So this past week we actually did a press release. We're asking Congress. I actually just talked to Phil Gately yesterday about an amendment to the Communications Decency Act, because many of you are familiar with Craigslist. Less of you are familiar with Backpage.com. I never heard of Backpage.com until I was elected, but they do the same thing as Craigslist as far as these ads. And I would suggest to you, when you see an ad advertising a young or tender girl, that means she's not 18. And we've been going back and forth with Backpage for years, and they will not stop selling those ads. And the GBI and other law enforcement agencies in the state are arresting a bunch of folks as a result of those ads. And we need more ability to prosecute folks that are, you know, from my perspective, if you buy the girl, you're just as guilty as if you sell the girl. So we've got to deal with the demand side as well as the supply side. There is no place to be buying little 12 or 14-year-old girls. So now let's talk a little bit about federal overreach that Louis brought up. So clearly my office spends an awful lot of time on federal litigation, an awful lot of time with the government. So we have five lawsuits against the EPA specifically regarding rules that they've come out with. One will be argued in the U.S. Supreme Court this fall on the cross-state air pollution rule. Now, you all will remember when the president came forward wanting to do cap and trade by legislation, so that failed. What you may not know is he then came forward with cap and trade by regulation. So we have this rule, cross-state air pollution rule, where he divided part of the country up into two parts. It doesn't apply to all 50 states, but it does apply to most Republican ones. And the part that we're in is Texas and Nebraska. Now, if you can show me one day on the weather where Georgia and Nebraska have anything related to air quality, give me a call. I'd like to see that weather report. But we're in the same mix. And it's not a fair issue, because if you take all the states that allegedly have credits, mainly D states, with, for instance, Georgia, Texas, and Nebraska that would need to buy credits, there aren't enough credits to buy. So the game's fixed before you even start. So the DC Circuit Court ruled 2-1 in our favor. It would account for about an immediate 20% increase in your power rates if we lose this case. We won in the DC Circuit. You're familiar, of course, with the President's war on coal. And now the case was just taken up in the U.S. Supreme Court. We'll argue it in the fall. The other thing we've been active with EPA is they have this cute little program with environmental groups, where if an environmental group wants to have the EPA take charge of a program, instead of going through the detailed rulemaking process where everyone gets a chance to comment, and then you can sue if you disagree with the final rule, what some of the environmental groups do is they go to the EPA, they draft a lawsuit, and they draft a consent order. They file the lawsuit, they file the consent order, and then you as the state or the industry are out of the mix. And you then have a court order telling you what to do even though you weren't part of the process. Now the environmental groups say, well, you know, it's good in America when you settle cases. It's also good when you know the case exists. And the way they do it, my first notice is the consent order being filed. And it's not to apply the Clean Air Act, it's to expand the Clean Air Act. And that's what Congress is for, not an executive agency. So many of us for 2 years were trying to do a FOIA request where we would find out all the documentation relating to what is called sue and settle, where you do exactly what I just stated. And there was a report recently that said that if you're an environmental group wanting records from the EPA, you generally get a fee waiver. If you're a government or an industry and you want to get records and a fee waiver, the answer is generally no. So we filed a suit in Oklahoma in federal court on that issue. One suit that you may not be very familiar with that we're one of 11 states in is Dodd-Frank. Dodd-Frank is to the financial industry what the Affordable Care Act is to the healthcare industry. So you create this Consumer Finance Protection Bureau. The budget is secret. The budget's under the Federal Reserve, and in fact it is a crime for a congressman to want to have a hearing to go over the budget. That's special. And then the Secretary of the Treasury, if he gets a 2/3 vote from the FDIC and the Federal Reserve using 7 factors, can file a pleading in federal court seeking to take over a financial institution. Now the company that seeks to oppose their takeover is able to argue 2 of the 7, which is also not American. And it is a closed proceeding. The filings of the proceedings are not open to the public. And if the proceeding does not occur within 24 hours, the U.S. government is the new owner of that business. 24 hours. If the government doesn't rule in 24 hours, case over. The standard for appeal is arbitrary and capricious, but once again, you're not able to see any of those documents. So we claim that's blatantly unconstitutional violation of separation of powers, etc. So we're in a federal suit in Texas, along with a community bank in Texas, on that issue. Of course, we were in the Affordable Care Act case, so you've got 3 quick issues I'll mention to you about. One, allegedly October 1, the individual mandates, the individual exchanges are online through the federal default program. So the first area there is there's a potential lawsuit that will occur. Actually, one suit's been filed in Oklahoma as to whether or not the employer mandates an option with the federal default as compared to a state exchange. You know, the majority of states have said no thanks to the state exchange and have joined the federal defaults. The second issue is the President's unilateral decision, in contrast to Section 1513 of the Act, to delay it for a year, the employer mandate, because it was complicated. Like we didn't know that before. So let me posit to you the following theory. If your goal in the first place is nationalized health care, and if you view the exchanges as more of national health care, and if you view employer insurance as private sector health care, delaying the employer mandate for a year based on complexity also potentially significantly increases the number of folks on national health care. And keep in mind that financial numbers don't make any sense here. Because let's say you're a young, healthy person that makes $30,000 a year. Your employer can tax you up to 9.5% of your wages. That's $2,850. Now, if you're a young and healthy person, so you think of yourself as invincible, and you don't need health care, are you going to pay $2,800, $2,850, or are you going to pay the penalty that starts at $100 and goes up to $695 2 years from now, and thereafter 2.5%? So by definition, young people voted for this bill thinking that they were going to get free health care. Young people are going to have the steepest increases in premiums because there's a thing in healthcare called community rating. And the standard community rating is 5 to 1. And putting that in English, that means that the variance between a young, healthy person and an older person not yet subject to Medicare, there was a 5 to 1 variable for what the premium cost could be. Under the Affordable Care Act, it's 3 to 1. So that means that the increases are less for older, unhealthy folks and far more for healthy young folks. You follow me there? Because you can't have more than a 3 to 1 difference in the premium. So by definition, if the president's goal was to get young people involved in insurance, it fails the finance test at that point. Third issue I wanted to mention to you for a second simply is the president's really gone overboard because now he has James Hoffa against him. And so you now have 3 unions writing a letter to the President and Congress demanding that they amend the Affordable Care Act. Why do they do that? Well, they do it, number one, because there's a 40% tax on Cadillac plans. And it's just not corporate CEOs that had them. The unions had them. Number two, if you have a Cadillac healthcare plan, you're not eligible for the subsidy. And number three, because the way to get out of the Affordable Care Act is to have your employees work less than 30 hours a week. The unions are all upset because that means many of their folks are going to be offered 29 hours of work a week instead of 40. So you're reducing people's pay, which really helps to be able to afford to buy insurance, along with everything else. So actually yesterday, the union that represents many IRS employees decided they didn't want to be part of the Affordable Care Act too. Isn't that special? You know, since they're supposed to be regulated. And then I'll take any questions you want on that. Finally, I want to talk to you about a case you probably don't know anything about, but which we did an amicus brief. We did what's called a friend of the court briefing. We do a lot of them in the U.S. Supreme Court. We did it on DOMO. We did it on the Voting Rights Act, all that type of stuff. So there's a lady in Pennsylvania who's not really very nice. Her name's Bonds, Mrs. Bonds. Mrs. Bonds had a friend who was a neighbor that lived near her. And they were really friendly until she got pregnant. And Mrs. Bonds started getting the idea that her husband was responsible for the neighbor's pregnancy. That created a little friction. And Mrs. Bonds apparently went to a store and got a chemical to hurt the pregnant neighbor. And apparently she put the chemical on like the doorknob of the house and the mailbox. And it is true that on one occasion her pregnant neighbor had a minor burn, I believe, to a thumb and a finger. No permanent damage, but an irritation from the chemical. And Pennsylvania was going to prosecute the lady for what she did. But the Justice Department came in and said, no, 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 that's ours. We're going to prosecute her under the Chemical Weapons Treaty and the enabling statute. So they literally told Pennsylvania, don't touch this. This isn't a state issue. It's a terrorism issue. It's a treaty. So they indict her in federal court. Case goes up to the circuit court. And she argues that under the principle of federalism, you could indict her in state court but not federal court. And that the 10th Amendment applies to both her and states, as the 10th Amendment is written. And the Justice Department said, no, that only relates to states, not individuals. You can't argue federalism. U.S. Supreme Court took the case up on a discretionary appeal, what we call certiorari. Now, I want you to assume that most cases that make the U.S. Supreme Court, the Justice Department or a state's a party to. Private citizens don't really have a good shot to get to the U.S. Supreme Court. It's just the system. So the Supreme Court takes the case up, unanimously overrules the Justice Department, says federalism relates, of course, not only to the states, but to her people. Case goes back down to the circuit court. The Justice Department then says, well, we got a new theory. It's a treaty with enabling legislation, and the treaty supersedes the Constitution. Circuit Court, based on what we call dicta, some language in an old case, rules with the Justice Department. She once again seeks certiorari in the U.S. Supreme Court. And once again, the U.S. Supreme Court has granted certiorari, where they're going to hear the case this fall. And the issue is, frankly, whether or not a treaty supersedes the Constitution. It better not. So my office is part of a brief in that regard. And the lawyer that they have arguing this in the U.S. Supreme Court is a gentleman named Paul Clement. That name may ring a bell with some of you. He was the lawyer who defended DOMA. He's the lawyer who defended Georgia on the the Affordable Care Act. He was our lawyer in front of the U.S. Supreme Court. Bush 41 Solicitor General, great lawyer. So we're paying a lot of attention to that case. And when I talk to groups, they frankly don't know about the Bonds case. But the Bonds case is crucial because the Constitution is what represents our country, not treaties. So it's important that we win that lawsuit. So at this point, I'll be happy to take any questions. I think I've only had 5 extra ones thrown out by the prior speaker. But ask me a question and I'll answer it. If it's tough, Trey gets it.
When you say treaty, you're talking about any treaty forward, not treaties before the Constitution, right? Any treaty we sign from now on would supersede the Constitution?
Under the government's perspective, yes.
Oh my God.
So it's a huge case. And it doesn't really get played. And I think part of that is because Mrs. Bonds isn't really a nice lady. But that's irrelevant from my perspective. I'm not seeking to defend Mrs. Bonds or what she did. I'm defending the Constitution.
Jesse Jackson, I think, requested a treaty on Zimmerman also. Wasn't that the case? That
I'm not going there.
Come on, man.
See that camera? I'll be happy to answer a real question. Yes, ma'am. Which of the 8 do you want to ask me?
This is different.
A different one.
Going back to the federal overreach on the EPA cross-state air pollution, and you mentioned the war on coal.
Right.
But I think, in things that I've been reading, that this is the first step, and he'll go after things like fracking.
Well, he already is. They've already proposed.
So what can Georgia do to protect our own natural resources?
Okay, well, you could put a windmill on top of your roof. Short of that. You know, look, clearly there's a process with coal, natural gas, etc. Clearly I disagree with it. I mean, I have asthma. I want clean air. I want the EPA to be based on science rather than ideology. It is astounding to me that we literally give billions and billions of dollars to countries that want to kill us and kill democracy, while we now have an amazing amount of energy within our borders and he doesn't want us to use it. That to me is just mind-boggling. One of my good friends is the Attorney General for North Dakota. For those of you who don't know, North Dakota has about a 2.4% unemployment rate. They have natural gas everywhere. And, you know, when the president, I mean, Romney was right. When Romney went up to the president in the debate, and he talked about all the increased natural gas that was being drilled, and Romney said, yes, it's all on private property because you pretty much stopped it on government land. Romney was 100% correct. Of course, mainstream media didn't want to cover the fact that Romney was correct, but he was. So what we've seen with this president is the mining of coal and natural gas, etc., are way down. But on private property, it's up because the states have taken charge, as they should. It should be the states, not the federal government. So by definition, the whole idea that we as a country could, for the next, whatever it is, 7,500 years, have ample energy, and this president doesn't want us to really use it, similar to the Keystone Pipeline. I mean, it's absurd. The answer is yes. You don't really need the State Department. The answer is yes. There could be something called a job involved in the process. So, I mean, we're very involved in that. The issue with the cross-state air pollution rule, other than cap and trade, by regulation, was we argued that it asked us to clean up more pollution than our state created. Our job's to reduce the air pollution in our state, not others. The other thing, the EPA denied what's our SIP, which is our state implementation plan. There's a theory that I'm sure some of you have heard about before called cooperative federalism, and it specifically relates to the Clean Air Act. And the theory is that the EPA tells you what levels you need to get to for clean air, but it is the state that chooses how to get there. And what the EPA did with the cross-state air pollution rule is say, we're turning down your state plan, we know better, we will now be in charge of that for your state. So we actually filed 2 actions, one with about 17 other states on the cross-state air pollution, and one relating to the action they took with regard to our state implementation plan. So just as I'm really busy, as Lewis was stating, the EPD, the Environmental Protection Division, is really busy because they're hand in glove with us on a lot of this litigation in that regard. Yes, ma'am.
Do you find that when you do these suits, or like 17 states together, do you find that most of the leaders, the attorney generals, are one party or another party, or is it mixed? Or I mean,
practically all of it is Republican. There's a couple Ds that sometimes assist us. That's generally Southern Democrats, the few that are left. So, for instance, Dustin McDaniel from Arkansas often is with us. Sometimes Jim Hood from Mississippi is with us. Sometimes, like we've been involved in some EEOC matters with criminal background checks, where some, for instance, Peter Kilmartin wrote a letter along with us, a former police officer, where it relates to public safety, we can get some buy-in. When we filed the Affordable Care Act, the Attorney General from Louisiana at that time was a Democrat. He took so much grief from the Democratic Party, he then switched parties and became a Republican. But at the time he joined that lawsuit, he was a Democrat. So I would say yes, and I don't say that to provide any criticism of Democrats, because I'm sure there's plenty of history where we had a Republican president and Republican elected officials looked the other way even though bad things were being done in the name of party unity, and I would suggest to you that there's no place for it. And at the same time, we criticize the Ds for not jumping in areas that they should now. We better be prepared if and when we ever get another Republican president, that when we disagree with that Republican president, we openly vocalize that opposition to him. So I think there's plenty of blame to go around in both parties in that regard, where the party in charge is too meek in opposing bad actions. And I think that that's one of the lessons that we need to learn, is, you know, neither party has the mantle of fair play and good policy, and we need to push for better government in that regard. Any other questions? Yes, sir.
I'm sorry. It's not a question, just a statement. I think we've all become aware of how important it is, over the last 6 years at least, to have an Attorney General that understands the Constitution and how the laws should be applied per the Constitution and under the Constitution. Georgia, I think, is really blessed to have an Attorney General who understands that,
Thank you, sir.
who does the job and does it correctly. And I'm just speaking as someone that believes and supports the Constitution, not as a Republican or a Democrat, although I'm a Republican. So I appreciate everything that you, I appreciate everything. In fact, I had to answer that question before we started dating. Are you a Democrat or a Republican? But I do appreciate all that you do and all that your staff does.
Thank you.
In order to make sure that the laws, Georgia laws, are primary and ultimately important in the application
Well,
of
thank
laws.
you. And let me suggest, well, first of all, thank you very much. But let me suggest to you also, we're winning the vast majority of this litigation. I know there's a lot of dismay, there's a lot of frustration nationally, you know, post-November election, etc. But we're really doing well in the federal courts. And while we don't win everything, no lawyer wins everything. But we're winning more than our share. So we're actually doing well. I mean, even if you look at things like the NLRB recess appointments, there's now 3 federal courts that ruled against the president. There is an A court that's ruled with him. That case is now in the U.S. Supreme Court this fall. So I think, and this is a gratuitous comment that wasn't from a question. When I see yesterday with like Chris Christie and Rand Paul, I get really nervous because other than the fact we were absolutely blown away by technology for the second time in a row in a presidential election, similar to Trey's comment, I mean, it wasn't close. The technology that Obama for president had versus the Republicans. I mean, we're child's play compared to where the Democratic Party is. Other than the last thing we need to do is infighting, because we got a hard enough time winning a national election now without infighting. And at the point that we're going to sit there and have different wings of the Republican Party fight with each other, you might as well get out of the process, because if we're not united, we don't have a prayer of winning a national election. And I'm very bothered by the fact that the energy is spent fighting each other rather than preparing to win the next national election. And so, for instance, right now, there's a huge election in Virginia for governor and attorney general. People need to be paying attention and helping those candidates out. Next year, if I look at it from my perspective as AG, the Colorado AG is term limited. So there's a new attorney general in Colorado. He's Republican. That is a tough save. The attorneys general in Michigan and Ohio are Republican. That's a challenge. Right next door to us in Florida, there's going to be tough elections for governor and attorney general. And I look at the infighting in our party and going, y'all are going to be fighting while we lose the war. And you know, with Trey's earlier comments about the state of political relations, it concerns me that we're into the weeds where we need to be into the bigger picture. And you know, the Democrats fight like hell until there's a primary winner, and boy, do they unite around that winner. The Republicans don't do that. We continue having the fight. And you know, the stakes are way too high for our country to be playing that game. Lewis.
The issue surrounding illegal immigration.
Sure, I knew you were going to ask me the immigration question.
Well,
He does every time I see him. Yeah.
Well, and for obvious reasons. I mean,
Sure.
It's, I mean, it's not just a matter of you know, having millions upon millions of low-skilled workers come to the country when we're at, you know, an effective 14+% unemployment rate, and the burden it places on the taxpayers with all the access to government programs and so forth.
Sure.
But you've also got, you know, even more critically, the criminal element. We know that, you know, that we're having Middle Eastern terrorists come up using the mules and the coyotes to come across the border. And when you got a president who refuses to enforce immigration law and protect the border, and then you have the Supreme Court ruling that, in many respects, handcuffs states from increasing their own border security. How do you combat that?
Okay, so let's answer your question in 3 parts. Number one, this president and his attorney general choose to defy many federal laws, not just immigration.
Right.
You know, I always thought when I was sworn in to defend the Constitution of the U.S. in Georgia, I was actually supposed to do it. 2, Arizona had a pretty big win in their lawsuit in the U.S. Supreme Court. Their win led to the Section 8 of House Bill 187, I think it was, being found legal. So when the Georgia legislature passed their immigration bill, there were 23 sections to the bill. 22 of the 23 are law. The only section that was stayed is Section 7, which was a minor section of the bill, from my perspective, relating to the overall bill that dealt with concealment or harboring of illegal immigrants. All the rest of the bill is law as we speak. And that was frankly due to the wins that were had in the U.S. Supreme Court in the 11th Circuit, which we won in the 11th Circuit. So it's once again one of those areas where we've actually done pretty well in the federal courts. The third answer is clearly we do need a new immigration law. But Border Patrol is first, second, and third in that process. And I'll give you an answer. You talked about education. I've had the honor to be the commencement speaker at Southern Poly, at KSU, in numerous colleges. When you are the commencement speaker and they are calling forward the new graduates in math and science, the majority of those graduates are not American. The majority of those graduates are from the third world coming here to get a great degree. And we then do all we can to immediately have them leave our country. At the same time, we have an insufficient number of citizens wanting to do the hard sciences. So I'm sure y'all can Google very easily the fact that in the next 20 years, a huge percentage of our engineers are retiring, but we're not replacing those engineers. So one of the things that I very much support, for instance, in a new immigration bill, is that those students who come here and get engineering, the hard math, the hard science degrees, if they want to become an American citizen, I want them to become an American citizen. Those are highly educated individuals we need in our country. And when they come here to get their education, we should not be discouraging them from staying here. Clearly, they got to go through a legal process to become a citizen, etc. But that's, for instance, an area where we need more immigrants, where we need more assistance. But I also agree 100% that until you actually secure the border, there's nothing to talk about. And it's clearly not going to happen with this president. So once again, that's what elections are all about. And elections matter. I mean, if you look at it from my perspective a little bit as AG, the Supreme Court is tenuous. The president makes those nominations. Same with the circuit courts, the district courts. If we lose another 8 years of elections, you don't really want to know what that Supreme Court's going to look like. So I happen to be one of those individuals that looks a lot about how the national election for president affects the Supreme Court. And when you look at the ages of those justices, you know, there's going to be numerous nominations in the next 4 or 5 years. And we need to be able to have a president that will respect the Constitution and support limited government. And that is crucial because, you know, when those Supreme Court justices go there, they're not gone in 4 years. You know, many of them are there for 20. It's a very lasting impact. So I think it's a huge issue that people just don't pay enough attention to, but that court matters. You know, the decision, right or wrong, I may disagree with the Chief Justice's decision on the Affordable Care Act as it relates to the tax and spend clause, but that decision matters and it lasts a long time. So the presidential election means a lot. And once again, that infighting among Republicans just is terrible. Yes, ma'am.
Just real quickly, and to kind of encapsulate what you're talking about, the election and how we need to gain our strength back as Republicans. The last election I saw one little news thing where Newt Gingrich and Herman Cain sat down together and just really built each other up. And I thought to myself, what a great concept that the people that are running against each other, they all have a fair percentage. I don't understand why they don't pick somebody else that's on the panel, because that group is going to follow their candidate and the other group is going to follow, rather than beating each other up. If they would kind of rally together, I would think we could gain a better percentage of support if they, instead of fought against each other, picked someone who wasn't popular, because by the time they all get up there and debate 4 or 5 times, we all pretty much see them and know them and are familiar with them.
But, you know, there's got to be a discussion that you actually want to win, rather than your ego.
Yeah.
And, you know, I mean, look at just 6 years ago. I mean, Barack Obama and Hillary Clinton were at each other's throats during that primary. But boy, did they sing from the same page for November. We had candidates that were still attacking the Republican nominee when he was the nominee. And now they want to run this next cycle. That makes me feel good. I mean, either you're there for the greater good or you're not. And I would suggest to you that if you're still attacking the nominee, then it's really your ego and not the country. And, you know, it's got to be about our country, not an individual.
Yeah.
On that Supreme Court ruling about the tax on
It's good.
Obamacare,
Yes.
wasn't that tax or that penalty instituted by the Senate and not by the House? So that when the Supreme Court ruled that it was a tax, wouldn't that negate the whole thing because it has to originate in the House?
Okay, so you're talking about the origination clause. And there's a whole series of cases that say that even if the bill doesn't start in the House and it's added by the Senate, because the House thereafter has to vote for it, and the bill itself did start in the House, that it's constitutional. So the important thing is that the bill started in the House, and that the House had to vote on whatever changes were made on the Senate. So I see that on the blogs quite a bit, but there's a whole series of cases that say the origination clause isn't as strict as you want it to be in that regard. I follow the blogs like everyone else, and but it's interesting. I got a pretty good law degree from Emory. Some of these folks on the blogs never got a law degree from anyone. And sometimes it's nice to actually have the degree. Everyone has a right to their opinion. And people will bring up arguments to me that I haven't thought of before, where I learned from them and it makes me a better attorney general. But I get really concerned when someone starts telling me they're a constitutional scholar from the internet. And I do have some of those opportunities going on in the state of Georgia. And everyone has the right to their opinion. And that's the beauty of our country. But sometimes I don't really rely on other statements. And I'm sure he's about ready to kick me off, but go ahead.
Yes, and one of the things that's interesting, we talked about this in RLG this year, is the oversight with this administration into the technology sector we're talking about in our personal lives. We talked about how we got our butt kicked this last 2 cycles because of technology. Imagine how they can monitor what's going on for the next election cycle if they do get into that and they do have the passwords and so on. It'll be almost a point of no return at that point.
You know,
it's much more than just our personal lives are getting into. They then can control a whole lot of things that are going on.
Of course, it was a Republican administration that started a lot of those policies. Going back to my earlier comment about both parties. A question I thought I was going to get that I did not get, so I'll answer it based on your question. There's a legal theory called standing, which simply says that you don't have the right, because you don't like what the government does, that doesn't give you the right to sue unless there's a particular injury that you have suffered from. So let me give you an example. The reporter, where they went in and got his emails to include his parents' emails, he has standing. He suffered the actual injury. You and I don't have standing, the state doesn't have standing, unless we can show affirmatively that they've gone into our records. But someone like that, where you know they've gone in, you know, the Fox reporter where they called him an unindicted conspirator, I mean, he has standing. So there's a lot of actions that people would like to bring about against the government, but you've got to be able to satisfy the standing requirement of actual injury before you could bring that case. Same thing when I talked about Section 1513 on employer mandates. As a state employee, I'm eligible for state insurance. I happen not to use the state insurance. I happen not to be a fan of the state insurance. But I don't have standing to bring that lawsuit because I have access to insurance from my employer. It would have to be someone who's harmed by that year delay to potentially bring that lawsuit. And of course, the problem is it would take longer to have the courts rule on that case than the year delay in that regard. But one of the things that I think the public's not familiar with a term like standing. And if we were able to just sue, I'd be in a lot of lawsuits, even more than I am now, because this administration does stuff weekly. But you know, I'll give you an example. We did an amicus brief on religious liberty, as it relates to Hobby Lobby, the Catholic Church, you know, Becket Fund. But I don't have standing because I don't have insurance from a Catholic employer or the Catholic religion. But as the state attorney general, I can do a friend of the brief. I can do a friend of the court brief, an amicus brief supporting the Archdiocese, the Becket Fund, or Hobby Lobby. So the attorney generals get active in the formation of amici, multiple amicus briefs, where we don't have standing. And we do that all the time, where we assist. That's how we did an amicus brief in DOMA. That's how we did an amicus brief in the Shelby County Voting Rights Act case. So we're involved in a lot of them. You know, we did the same thing with Mrs. Bond and the Chemical Weapons Treaty. So that's how we do that. We get involved in those cases by filing amicus briefs because we don't have standing to be in the actual, as an actual party. So we do a lot of that work. And similar to the comment I think that you asked, the states work together. So it's not my Solicitor General having to draft the whole brief. They can divide up sections. They can, you know, so there's a whole group of states that will provide assets to assist the formation of those briefs. And then they'll do a draft. They'll hand it out to 15 other states or so that are interested. Everyone will make proposed changes, and then you have a better work product. So it's the collaboration that really helps us do what we need to do. Because none of us have the staff to be dealing with the federal government. You know, I've been in phone calls with Justice where they ask you questions about bills the legislature passed to see which state to sue next. The federal government has a lot more resources than any of the states do. But, so we work together in that regard. Okay. My honor to be with you all this morning. Were you going to ask something? No. My honor to be with you all this morning, and thank you very much.